Good day, everyone. Thank you for joining me again for this live webinar dealing with an interesting topic in relation to family law, child maintenance. An interesting thing about child maintenance for me professionally is it's the first field of law whereby I actually practiced. Years ago, almost 2 decades ago, I appeared in the maintenance court in Simonstown and I had to represent a client for maintenance, and the father said he cannot afford to pay maintenance, and we proceeded against the grandparents. The child was born out of wedlock. The magistrate, applying the law at the time, said you cannot claim maintenance from paternal grandparents of a child born out of wedlock. The law does not allow that based upon the common law. I, of course, challenged it in the Western Cape High Court, and the Western Cape High Court declared yes, the legal obligation of the paternal grandparents of a child born out of wedlock is no lesser than the legal obligation of the maternal grandparents of a child born out of wedlock. So after that case, many parents, or mothers at least, applied to the maintenance court for maintenance against the father's parents because the father could not afford to pay maintenance. Obviously, it makes logical sense. Many times the mother falls pregnant, the mother of the child falls pregnant, and the father is quite young. He might be at university, or sometimes school, or unemployed. And the law said that her parents have a legal obligation to maintain the child. And the law at the time said that his parents have no legal obligation. Unfair. Maybe the father's parents have more money to maintain the child. So that changed. And it makes logical sense to go against grandparents for maintenance if the parents cannot afford to pay or maintain the child or support the child. Therefore, quick advice, not necessarily the topic of discussion today. If the father or the mother, depending upon who's the guardian or the primary caregiver of the child, parent, the other side, cannot afford to pay child maintenance, then you may proceed at the maintenance court or the relevant forum for maintenance against the grandparents of the minor child. So just bear that in mind. It does not mean that the parents cannot afford to pay maintenance. It cannot climb up the ladder. However, today's topic, when do I approach the maintenance court? Interesting topic. And I find it very interesting because many people, and I find it weird, for lack of a better term, they'll approach me, and they're professional people, and they'll ask the question, can I claim maintenance for my child? And they were not married. They'll say stuff like that, or she and the father never lived together. She does not necessarily have much contact with the father. And the question is, can I claim maintenance? Does the law expect the father to pay maintenance? And the internet is full of it. You can look up articles, there's newspaper articles, journal articles, and so on, dealing with this topic. But nonetheless, it's still a question that gets posed quite often. And I can presume if you do not have a child, you do not find this topic necessarily relevant. You won't apply your mind to it, but once you have a child, fall pregnant, and the other party is not paying maintenance, automatically becomes relevant, and now you obviously have questions. For example, I was not married. The father of the child is disputing paternity. What do I do? Do I have a right to claim maintenance, and so on. But when do I approach a maintenance court? So obviously, the first requirement would obviously be that there has to be a child. We cannot claim maintenance against someone if there is no child. If you look at the Maintenance Act, it refers to a child. So if you are pregnant, we can maybe theoretically approach a maintenance court, but they'll most probably tell you, ma'am, you have to wait till the child comes out. How can we determine an amount, determine expenditure, and all those things if we do not have a living child? We don't have a name, we do not have an ID number. So let us wait the 9 months. All the best for the pregnancy, and let us then deal with the matter. So there needs to be a child. Once the child is born, and hopefully the child will be a healthy child, but once a child is born, Obviously, certain expenditures were incurred regarding the birthing of the child. Those specific expenditure you can claim from the other party. So if you look at our questions, we touch on that a bit later on. And whatever expenditure that has been incurred after the birth up till the time you're going to claim maintenance. But remember, the maintenance obligation of parents is determined based upon their means. Meaning, it does not mean that the father must now pay everything regarding the child, or the mother must pay the majority of the expenditure regarding the child. You have to pay according to your means, what you can earn, what you can afford. And it's important to note that means does not mean income, your salary. A father might have an income of, for example, 100,000 rand per month. I'm using silly figures. And the mother's income might be 10,000 rand per month. But the mother owns assets worth millions of rands. Her means are different. Her income might be less, but the means are much different. And therefore, the mother's, sorry, my apologies for that. The mother earning less than the father should not be the deciding factor. We need to consider she has assets as well, and assets that are accumulating and so on. So you have to look at the party's means. Moving forward, the mother's attitude should not be, you the father, you made me pregnant, you should pay for all the minor child's expenditure. The law does not stipulate that. The laws stipulate, as mentioned earlier on, you have to pay what's fair and in terms of and according to your means. So you have to work it out. Okay, I earn so much money, the medical aid did not pay for these specific expenditure, X, Y, and Z. A fair contribution on behalf of the father should be X towards the birthing expenditure. But now moving forward, the child is now obviously on diapers, maybe formula milk, does not eat that much because it's quite a newborn child. It's a newborn child. Therefore, you have to now determine what would be a reasonable amount to pay. Obviously, you do not know before the time. You still have to incur those expenditure. So I always advise people, the first few months of a child's life is a really difficult time to determine how expensive a child would be. Does a child use 3 or 4 nappies a day, diapers a day, or 6 or 7? I do not know. Does the child eat formula? Drink formula, my apologies, or does the minor child is he weaned over the breast? So whatever the facts are, so those affects the economics of these things. Does the child require a lot of clothing or little clothing? Accommodation. Did you have to purchase anything for the minor child? Did you have to purchase a cot, a car seat, whatever the facts are? These are important things to determine. It usually becomes much easier once things stabilizes, after maybe 6 months, where things are a bit easier to work out, and certain milestones have, been dealt with. Obviously, once a child is at a certain age where he's off the nappies and off the formula and eating adult food and attending daycare, then the expenditure are more stable, it's more constant, and the next milestone might be when the child attends daycare, primary school, and going further from there. But the long and the short of the matter is we need to determine what the child expenditure are at the relevant times, because the other party will have to pay maintenance based upon those expenditure. There is no legal obligation upon the other party to maintain you unless you are maybe married to the person, and there is some type of a legal obligation for that to happen. But if the person made you pregnant and you have a child with that person, the general answer would be he has no obligation to maintain you. I hope you understand where I'm going to with this. Okay, so dealing with the question, when do I approach a maintenance court? You approach the maintenance court if the other party is not willing to come to the table regarding child maintenance. That's my answer. If the other party is willing to come to the table and you guys discuss and you guys come to an agreement and you are happy with this agreement and understanding, it's reasonable under the circumstances, why approach a maintenance court? I do not see the logic behind that, because you two are in agreement regarding the specific expenditure of the minor child and you are both happy with that. If you are not happy with that, and I'm referring here to the complainant, the person approaching or obtaining, receiving the maintenance, if you are not happy with the contribution being offered by the other party and you guys cannot come to a reasonable agreement regarding those specific expenditures or contribution, whatever the case may be, then of course the matter will have to go to a third party. And the best third party would not be a family member or a friend. It will have to be a specialist institution, a specialist person, the maintenance court, the maintenance officer, the maintenance clerks, those specific people that deal with maintenance matters on a regular basis. Under those circumstances, I would advise you to approach a maintenance court if the parties cannot come to an agreement. If you ask me the question, can we have these discussions with the other party? He is paying something that's reasonable, but also have that agreement been made in order of court. Wonderful. I think there's nothing wrong with that. If you are maybe concerned that the other party might decide not to pay in the future and he's willing to do so. But if the other party is stipulating, there has never been problems in the past. I always paid what you asked and whatever was reasonable. If there was some disputes, we resolved the disputes and we were happy after that. And I would be happy to continue with that agreement indefinitely. Wonderful. Then there's no need to go to the maintenance court. And of course, that agreement will obviously have to be in writing. So if you do approach the maintenance court will obviously take note of that agreement and the maintenance court can enforce that agreement. So question number 1. My child is 3 years old and the father pays what he wants on and off. So he pays whatever he feels like, and some months he doesn't pay and some months he pays. He says that if I take him to court, I will get nothing as he's self-employed. Is that true? Now that's a question or scenario that comes to my table on a regular basis. On our online blogs, on our online questions, we find that problem a lot, whereby the father, and I'm dealing with the father because the children is young and the mothers are generally primary caregivers. The father gives what he wants and he tells the mother, warns her, if you go to the maintenance court, you will not get anything. I think that's nonsense. You should not listen to the father. You should go to the maintenance court. And you should tell the maintenance court what he said, but that's not obviously won't make you win your case necessarily. And obviously, if he paid the last few months X, Y, and Z, whatever amounts he paid, he obviously could have afforded it. It doesn't mean now just because he went to the maintenance court, all of a sudden he can no longer afford it. He will have to come with his income, expenditure, bank statements, etc. And he has to prove how does he live, how does he eat. And if he is alive, obviously he's eating. He's living somewhere. He paid transportation costs to get to the court wherever he is. Some of that money should obviously go to the child, to the child, and for the child to be maintained. So do not be afraid of people who threatens you by stipulating that if you take me to the maintenance court, you will get nothing. That's all nonsense. Go to the maintenance court, and the maintenance court will sort that person out. Question number 2. Is it possible to claim maintenance for birthing expenses and up until the date I took the father to court? My apologies for that. So, can you claim for birthing expenditures and up until the date you took that father to court? My child is 6 months old. So basically, the child is 6 months old, you approach a maintenance court, you want to know whether or not I can claim for the birthing expenditure and unpaid maintenance or whatever expenditures you incurred for the last 6 months because the child is 6 months old. Yes, you can do that. The maintenance form makes provision for that. So you're welcome to make that application. Obviously, the contribution that the father should pay towards that would be on the same maintenance principles according to his means at the specific relevant times. So if you earned double the father's income, of course, you will have to pay double. The contribution of the father for that specific period would be 1/3. So if the child costs 1,000 rand per month, he should only pay 330 rand for that specific 6 months per month as child maintenance. I follow you follow where I'm going to. Same regarding the birthing expenditure and so on. So you can do that. Many people do not know that. Many people do not. And I'm serious about this point. When they approach a maintenance court, the father has not been paying maintenance for the last 5 years. They do not ask the maintenance court that the father should pay backdated amounts. You need to expressly stipulate, I want the father to pay all those months, all those years he has not been paying. He should contribute towards that because he had a legal obligation to pay maintenance for those specific periods. Question number 3. What do I do if I do not know where the father lives? He has not been paying maintenance for the past 3 years. The child is going to school next year. Typical question I receive on a regular basis on our blogs and so on. If you cannot find out where the father lives, it's so easy to nowadays for people to determine or to find people. For example, I'm certain the father applies for accounts, for loans. You provide his details. I'm certain he has a cell phone. We have to FICA these specific numbers and so on, you would have provided his number. It's really easy nowadays to find someone. People are not, unless a person disappeared from the face of this earth, change his identity or her identity, it's easy to find. And the Maintenance Act has changed, allowing people at present now to be able to use Vodacom, Cell C, Telcom, and whatever the case may be, to track people in order for you to claim maintenance from them. So I'm certain if the person has WhatsApp, clearly the person has a telephone number. I'm certain some way or another, Vodacom and Intel and all those places can find out where this person is living. Or you can do a credit check and find out where last the person applied for credit. The person obviously has family members. You can ask the family members. It's not impossible unless the person disappeared completely. I hope that answered all your questions regarding the topic when you approach a maintenance court. You approach a maintenance court the moment you guys cannot come to an agreement regarding child maintenance. You let the maintenance court resolve that issue. Thank you very much. Have a lovely day. And before we go on, remember, there is a webinar taking place on Saturday. I would like each one of you to register. The details are on the screen. Please note, the webinar is free of charge. If you have any family law legal questions, you're welcome to pose it now when you register, and I will deal with those specific questions live. If you cannot attend the webinar on Saturday, please still register, because later on I will send you a video of the webinar and I would have dealt with that specific question. So thank you very much. While I end this video, please register for the webinar. I'll see you online tomorrow, hopefully.